Thanks very much for joining us today. We wanted to, I think we're going to focus mainly on the privacy law reforms today, although we do also at the end have a little grab bag of some other key developments from the last year that hopefully we'll get to. I'd echo what Catherine said with respect to questions. To the extent that you have questions, if you could sort of input them into the chat as they come up, that might be best, because then we'll have an inventory of them ready to go towards the end of our presentation. So by way of a roadmap then for what we're going to go through today, we're going to talk, I'm going to talk about, in general terms about the lay of the land, how the privacy law framework works constitutionally and across the various provinces, and talk a little bit about some of what's been going on in British Columbia and Ontario, and then we'll dive into the new federal privacy bill, the Digital Charter Implementation Act. I hand it over to Michael, who will talk about Quebec's Bill 64. And then, as I said, hopefully we'll get to some key privacy decisions and developments. And we have included an appendix that we may or may not get a chance to speak to at the end, but just trying to compare the new federal bill with the Quebec bill and the European General Data Protection Regulation. Even if we don't get to that, that will be in the materials that get sent to you following the presentation. So there has been a real wave of, well, I guess that, oh, sorry, we're doing the legislative framework first. So by way of very quick overview and background, there's a mix of provincial and federal laws in Canada that govern privacy, and it cuts across sort of three different sectors. There are public sector laws in each of the provinces as well as federally, and those laws also include freedom of information laws for the most part, other than the federal law. There are health sector laws in all of the provinces, or most of the provinces. But what we'll be talking about today and what is of interest to most businesses are the private sector privacy laws. There are four of them. There's a federal bill that governs all commercial activity, personal information collected in the course of commercial activity, unless in a province there's substantially similar legislation. And there are three provinces currently that have substantially similar legislation. So if we can just go to the map, yeah. So this is how it shakes out. So the provinces with their own laws are BC, Alberta, and Quebec. And really, the federal law, PIPEDA, applies in the rest of Canada with respect to commercial activity. And as some of you may know, there's a bit of a hole there in terms of how it applies to employees. So it does, well, it applies to commercial activity in all of those green provinces that you see on the map. It only applies to employees of federally regulated businesses. So there's been a real wave of privacy reform in Canada, or at least discussions and the impetus of a wave of reform. Influenced, I think, by a number of factors. One of the key ones would be the GDPR, the European law that's been enforced now, I guess, coming up on 3 years, which has significantly changed the landscape and struck fear into the hearts of many businesses. There's also been, increased activity in terms of data breaches and concerns about adequacy of data security. As technologies develop, particularly sophisticated artificial intelligence technologies, and even just more sophisticated data analytic tools and abilities to combine very disparate sources of data and come up with some really interesting predictions and observations. I think about the Cambridge Analytica scandal and those sorts of things has certainly given some lift to the need for reform. And there's a general, I think, fear and uncertainty about network technologies generally. So we're seeing a lot in Canada in terms of development, and as sometimes you'll see it looks a bit like a contest to see who can levy the biggest fines. We'll get to that in a minute. So just to mention very quickly something about what's been going on in Ontario and BC. Some of you would have seen Ontario put out a discussion paper last summer proposing an Ontario private sector privacy law, which that province does not have its own private sector privacy law currently. Way back in the early 2000s, it did have a bill, but it never made it to legislation, and the province has been seemingly content until this point to exist under the framework in the federal law. The Ontario paper proposes a number of changes, citing what it perceived as deficiencies in the federal law. And there was a comment period, and we'll have to see what happens now, particularly that there was a significant new sort of federal bill introduced, and whether Ontario will still feel it wants to move forward with its own legislation. British Columbia already has a private sector privacy law. There have been calls for reform within that law as well. Like a lot of these privacy laws, there's a mechanism requiring a regular review. And part of that regular review, there's a special committee, a legislative committee that was struck to look at their law, the Personal Information Protection Act for BC, and to talk about potential amendments. There were a number of amendments proposed, and some of them, quite strong positions put forward by BC's Information and Privacy Commissioner, looking for increased enforcement powers largely, and introducing a mandatory breach reporting requirement for that province. Again, we'll have to see where that goes. That was just a committee report, and as we know, committee reports don't always find their way into legislation. So that brings us to the federal law. So this law was introduced this fall in November. The title of the bill is the Digital Charter Implementation Act, and it does the things that you see on the right side of your slide. So, one of the notable things it does is it repeals PIPEDA, or at least the first part of PIPEDA. As you know, PIPEDA stands for Personal Information Protection and Electronic Documents Act. If this bill is passed, the electronic documents part of that law would continue, but the personal information protection portion would be replaced. So this isn't just an amendment to PIPEDA. This is really sort of tearing down and seemingly starting again. Although you'll see that quite a bit of what was in PIPEDA has been reincorporated, at least conceptually, in the new law. So what it takes away PIPEDA, it enacts two new pieces of legislation. One of them is called the Consumer Privacy Protection Act, which is a new sort of the replacement for PIPEDA. It also enacts a Personal Information and Data Protection Tribunal Act, and I'll talk about the tribunal in a moment, and then makes a bunch of consequential amendments, as these things always do, to other statutes that are impacted. So if we look at what the bill does, I really think of it as sort of PIPEDA 3.0. So, all of the principles that are currently in PIPEDA are pretty much continued on it. But it's recast. Those of you that are familiar with PIPEDA know it's a somewhat unusually structured law. In that the heart of it is really in a schedule to the law, and that schedule is in fact a model code that was created by the Canadian Standards Association. So the law really says you have to comply with this code And here's a couple of derogations from what that code says, and here's some additional requirements. So it recasts all of that into more traditional legislative form. It includes a lot of the same types of exceptions to consent and things, but then it adds to all of these things. And so some of the significant things that it adds, which I'll talk about in more detail, are enhanced enforcement powers. You'll be aware that a long time the Privacy Commissioner of Canada and his predecessor have been lobbying hard for additional enforcement powers, or really any enforcement powers. The current commissioner model is an ombuds model. There's broad powers of investigation, and there are powers to issue reports of findings and recommendations, but no order-making powers, no powers to directly impose financial penalties. And it creates a new tribunal that would impose penalties in this case. So it's still not the Privacy Commissioner that would directly impose the penalties. The Privacy Commissioner would conduct an investigation and would recommend certain cases as meriting the issuance of administrative monetary penalties. And then that goes before a new tribunal that would be created that would allow that to happen. Sorry, can you just go back a slide, Michael? Just so I just want to make sure. I guess I will cover a lot of these other things, but exceptions to consent, a stronger standard for consent than what we've seen, and clarifies a number of things, I think, quite helpfully, like outsourcing and cross-border outsourcing. There's some useful to business clarifications there. So there's some more problematic things depending on what the final version of the law looks like with respect to topics like de-identification and automated decision making. And there are a couple of enhanced and I guess new individual rights. Thanks, Michael. So there are two I've classed the new enforcement powers really into two groups. And the first one are new powers that are handed to the Privacy Commissioner himself. So the first is there are order making powers. So again, this is brand new. The Privacy Commission does not have order making powers currently. So they can make both mandatory and prohibitive orders, stop this practice that infringes the privacy law, or, as you go forward, implement this new mechanism, this new consent collection, so this new record keeping practice or whatever, and again, in order to comply with the law. He also has the power to order compliance with a compliance agreement. There's currently in PETA the opportunity that after an investigation, an organization could elect to enter into a compliance agreement with the Privacy Commissioner. But there was quite a complicated and somewhat time-limited process for how the Privacy Commissioner would deal with a breach of that agreement, a company entering into an agreement and not honoring it. Now there would be a particular order-making power that said, you have to comply with this. There's the ability to require the issuance of corrective notices. There's also an interim order power, which is kind of an odd thing, the way it's structured. It comes up in a procedural section, but it's not clear that it's only limited to kind of interlocutory matters, and so that's a matter certainly to be clarified. Any of the orders can be registered with the federal court in a familiar mechanism that's in use with a number of federal tribunals. There's also an audit-making power, which again is new. This is something that the Privacy Commissioner wanted. He wanted quite an open-ended audit on demand power. He has a limited audit power now that he can audit on reasonable grounds in certain cases. He now, it's sort of a hybrid of what he wanted and what he has now. So he has a bit more open-ended audit power, but it's confined to reviewing compliance-related documents only. So, your internal privacy policy and procedure documents is all that he can, require that you provide for audit purposes. And there's a proviso as well that anything that's audited in that way, any of the findings, that cannot be used as a basis for a complaint or investigation. So, and the final power, which has always been the case, is publicity, which I often think of as the power of public shaming. So, following an investigation, the Privacy Commissioner can publicize findings, which doesn't always happen, but you'll all be aware of some major cases where names were named and press releases were made and that sort of thing. And it can also make other types of information public in the public interest. So those are pretty significant changes. Again, it's short of all of what the Privacy Commissioner wanted, but it's a significant change in how things work currently. There's also a set of enhanced enforcement powers that are really in the hands of other entities. So the first one, as I said, there's this new tribunal that's been created or would be created by the bill, and it's the tribunal that would have the power to issue administrative monetary penalties. And these could be significant. Again, it could be up to $10 million or 3%. Global gross revenues, whichever is greater. And these are penalties which are similar to kind of GDPR sort of numbers, and certainly very substantial. There are some limits on that. So in some ways, it's not quite as bad as it looks. First of all, of course, these are maximums, and the experience in Europe has been that the maximums are not usually reached, and the whole point of having the maximums is just to give room for the imposition of sufficient penalties to deter the behavior. So there's that, but it also only applies to certain parts of the Act. So only certain types of violations under the Act can give rise to administrative monetary penalties. And so those would include over-collection of personal information used for a new purpose without consent, requiring as a condition of service that an individual consent to sort of secondary purposes, which are often marketing-related purposes, consent by deception, security failures, breach reporting, that kind of thing. So it's a narrower set. In addition, AMPs are only available after there's already been an investigation and a finding of some sort, either by the Privacy Commission, by the tribunal, which also acts as a kind of appeal body from Privacy Commissioner decisions, or by a court. Because there are offenses under the Act as well. So, and that which brings me to the offense provisions. There were offense provisions before, or are currently under PIPEDA. They're very seldom used. These continue, but they've been added. And again, it's a limited subset. So it's breach reporting, failure to keep records of a breach, re-identification of personal information is one new one. There continues to be whistleblower protection. And there's a new offense of general noncompliance with OPC orders. So these would be, offenses prosecuted by the Attorney General. We'll see where that goes. And then finally, what's new here, and I'm sure would be of interest to many businesses, is there's a new private right of action in the law. And basically, again, it would arise once there has been a finding by the Privacy Commissioner, the tribunal, or a court. So there's been some finding of a violation of the law. Once that happens, an affected individual can sue for damages for resulting loss or injury. The good thing I can say about that is it doesn't provide for statutory damages, and it's still only in cases where there's already been a finding. But obviously, that kind of private right of action will be of concern to a lot of companies, and for larger and systemic investigations, I guess could well be the basis for class action litigation. So that's enforcement. There's also a number of important changes on the consent front. Currently, PIPEDA is very much consent-based. The default rule is you can only collect, use, and disclose personal information with, the knowledge and consent of the affected individuals. And you know what? One of the things that often isn't realized is, in fact, the GDPR in this way, in some ways, is less stringent or more flexible than PIPEDA, because there are other grounds for processing recognized by the GDPR that include legitimate business interests and fulfillment of a contract, where you don't need consent, provided that all the uses and disclosures of the information you collect, fall within certain bounds. So there's been attempts now to introduce that kind of a concept into the CPPA. So there's a new kind of business activities exception that provides that consent would not be required in a range of circumstances that I've set out here, where a reasonable person might expect such collection and use. And so this is kind of a hybrid, I think, of some of the GDPR-like exceptions for fulfillment of a contract and legitimate interests. And it's interesting because it says, it doesn't say there's implied consent. It says consent is not required, which means, the rights that exist to withdraw consent, which we'll talk about the rights a bit later in the presentation. They can't be withdrawn. Like, if you didn't have to give consent in the first place, you can't withdraw consent. So an individual can't withdraw consent for any of the types of activities or uses that are included in this new exception. So I think this is very good for business. And it will also, and one of the motivating factors for this is it will mean businesses won't have to put as much in their privacy policies and their privacy disclosures. And those documents will now be able to focus more on the outliers and the types of activities that might be beyond people's reasonable expectations. The trade-off to that, though, is that where consent is required, the standard appears to have been made more onerous. Currently, PIPEDA provides for both express and implied forms of consent on kind of a sliding scale. The more sensitive the information, the more likely it's going to require express consent. The less sensitive, the more likely it will be permissible to use implied consent. That's been restated now in a way that makes it very clear that the default is explicit prior consent. And there are also some enhanced or more detailed, more prescriptive disclosure requirements about the sort of information organizations have to provide when they seek consent, when they obtain consent. It is still possible, apparently, to have implied consent in some circumstances. And it really, the law just says where, a business concludes it's appropriate in the circumstances. Well, what does that mean? And what kind of potential liability is there for a business that gets that wrong in terms of determining when implied consent would be appropriate? So some good news. There's also been some other, in terms of good news, some really useful clarifications about outsourcing. And some of you may recall that there was a whole mess recently where the commissioner changed longstanding practice or changed the longstanding approach to how outsourcing was viewed, particularly international outsourcing, which was subsequently fixed, but this is now a lockdown in the law. So the clarifications are that you don't need consent to transfer personal information to a third-party service provider where they're providing a service on your behalf or providing a service to you and they require access to that information. There is also no consent required to engage a service provider outside of Canada or to otherwise transfer personal information outside of Canada. You do still have to provide notice, which is currently required by Privacy Commissioner recommendation or guidance. It's now a hard and fast rule. And there are new obligations that are imposed directly on service providers, which is new. And there's been some uncertainty on the point about to what sorts of organization does the federal law apply? I've long been of the view, and I think when you read it in its totality, that the focus is on what the Europeans would call the data controller, so the parties that control the use of and collection of data, and not on processors, not on third-party service providers that handle that data or process it on behalf of a controller. There are others that take a different approach. And so the bill does, I guess, two important things. Is one, it clarifies that if you're you're not generally speaking subject to the law, which I think is helpful. It clarifies that. Except it does say you are now directly responsible in two ways, and this is common in a lot of privacy laws, and it's already common in some of the provincial statutes, including some of the health privacy statutes. It says you are subject to the law with respect to, security and breach obligations, which are things that currently the outsourcing company would be responsible for including in a contract. And this really just backs that up. So if you're a service provider and you handle personal information on behalf of another party, this really just adds the fact that you could now be in violation of a statute as well as a contract if you don't adequately safeguard that information, if you use it for purposes other than for what it's intended, and if you don't notify the controller in the case of a data breach. So that's new. But still, I think overall, I think those are businesses will find those to be helpful clarifications. Another area that is a bit of a mixed bag, I guess, is in the area of de-identification. And so I'm trying to even think how to put this forward. Oh, this is on the slide shows what the definition is for de-identify. And the problem here is if it really sort of raises sort of existential questions, if I can put it that way, about how the law applies, because privacy law now applies only to personal information, and which has been interpreted, well, for one, it's defined to mean any information about an identifiable individual, and the courts have determined that that includes application to information that together with other available information could be used to identify an individual, subject to a kind of standard of reasonableness. So if you take away factors from your data set that make it extremely unlikely or impossible that the data could be associated with an identifiable individual, that's not personal information. That's not subject to the law. Unfortunately, the way they've defined the term here to sort of mean what the law, what the courts have found. So they've defined something that really on its face should not be personal information, but then they attach in the law restrictions on how that can be used and requirements, about how it should be stored and protected, and limits on who has access to it. So on the one hand, it's sort of they define this term that looks like it says this isn't personal information, and then it includes other provisions that treat it like it was personal information. It looks like that really wasn't the intention. And the idea here is, one of the things that the law includes is which follows on the government's sort of digital charter, is it includes provisions that allow for disclosure of personal information in certain circumstances to public bodies, healthcare institutions, and other things where the data could be used for socially beneficial purposes. And so I think the intention was to just create a definition here that provided a stepstone to facilitating that broader sharing for the public good. Unfortunately, the way it's written currently is disastrous for business and anybody that that uses de-identification as a responsible strategy for minimizing risk internally in terms of security, or does it for other purposes, external R&D and things like that. So it's a mess. I think it's going to be, I'm optimistic that it's going to be at least partially fixed. And I've been involved in a number of meetings with various industry associations and coalitions with industry or ISET officials, Innovation Science Economic Development Canada officials about this, and I'm optimistic we'll make it better, but we'll see. And I'm almost done my part before I hand it over to Michael. Another really interesting development, and this is somewhat consistent with developments in Europe, relates to the concept of algorithmic transparency. What it talks about is automated decision systems. And in Europe, as some of you may know, there's actually, there are transparency requirements about the type of sort of AI processes and automated decision-making processes that an organization uses. But there's also a statutory right for individuals in some cases to object to that, to say, no, you can't do that with me. You have to, use old school processes rather than automated processes. The new federal bill doesn't go that far, but it does include transparency requirements, and there's sort of two flavors to the transparency requirements. One is to provide a kind of make readily available to everyone a general sort of summary level description of your use of that kind of technology, how you might use the automated technologies to make predictions, recommendations, or decisions, including, to make recommendations to human decision makers, but only in ways that would have a significant impact on individuals. So, okay, fair enough. Some companies do that anyway as a best practice. And then I think more problematically, as part of an access request, there's long been requirements in privacy law that individuals have a right of access to any personal information that an organization holds about them. As part of that kind of a request, an individual could ask for a more detailed explanation of any automated decisions made about them and how their personal information was used. And I think the problem there is because it doesn't have that proviso about a significant impact, given the level of automation in even very routine kind of administrative or logistical matters, that could be a really onerous requirement. If you think about it, something as simple as, someone calling into a call center that automatically will route the call to a call center in a particular of Canada or the world based on, time of day, for example, time zone, is a form of automated decision making. Someone is calling in, there's an automated system deciding where your call will get handled. Theoretically, I and others are concerned that would be caught by this, and you would have to provide an individual with some detailed information. So watch that space. And I think, the final thing is there's two new or amended individual rights in the federal law that I think are worth mentioning. So the first is a right that's similar to what exists in Europe right now, which they're calling a data mobility right, which is the right to have your personal information transferred from one organization to another. And the example, the obvious example is if you're changing banks, for example, and there's been a lot of discussion in that area, open banking, and what can you do to facilitate that transfer. I think these are really motivated by competition-related concerns that they want to, often one of the deterrents to people switching service providers is the loss of all of that historical information and having to start again or having to do it through some manual process, which can be daunting. So the idea is let's agree on some kind of format and process where all of that data can be readily sent back and forth. And there's precedents for that in other industries. Telecom comes to mind in particular. But that's a new right. It will be targeted to specific sectors or types of activities, which is good news, because at one time when we first heard about this, it sounded like it would be across the board. And there was a concern that, you know, all kinds of industries where there's people really have no interest in moving that information from to another, you know, like a retailer. You know, if you decide to shop somewhere else, it doesn't really make any sense to force a different store that you dealt with to provide all of your, you know, shopping records, all the purchases you made to another party. I think it's helpful to know it's going to be targeted. The problem is we don't know yet how it's going to be targeted. That's a battle yet to be fought. All of that's going to be implemented through regulations that we haven't seen yet. So there'll be a whole subsequent, once this bill is passed, there'll be a whole other process for those regulations and a comment period, et cetera, et cetera. The other, which is not really a new right, it's I look at it more as an enhancement of a right, is what they're calling a disposal right, where an individual can request you know, deletion, erasure of personal information that an organization holds, including in the hands of third-party service providers. So if an organization gets this type of request, they not only have to dispose of the data themselves, they have to reach out to any third parties with whom they've shared that information and ensure they do the same. It is subject to, I think, broader statutory exceptions than in Europe. So reasonable terms of a contract that would prevent disposal, statutory requirements, impediments to, you know, full exercise of the disposal right. I look at it as an enhancement because there's already a broad right to withdraw consent in the federal law, and I think this just really makes it a little bit more clear that it could include, you know, erasure or disposal. But it's not the so-called right to be forgotten that we see in Europe. I don't think it goes that far. So I think I've gone more than over my time, but that's what the federal bill says, and I'd like to hand it over now to Michael, who's going to walk us through Quebec's bill.
Thanks, David. Bill 64 is the proposed overhaul of Quebec's private sector privacy legislation. As David mentioned, Quebec is one of 3 provinces to have its own private sector privacy legislation. The bill also, and for those who kind of do work in the public sector, the bill also makes similar changes and other changes in the public sector privacy legislation, as well as consequential amendments. I'm not going to cover that in this overview, but many of the changes are similar as between the private sector legislation and the public sector legislation. So Quebec, Quebec is a leader in privacy law, having been the first province to implement a private sector privacy legislation back in 1994, and then followed by PIPEDA federally in the early 2000s. One of the, because it was implemented in 1994, and there's been, obviously, huge changes in technology, including technology that monitors and surveys personal information, as well as the GDPR and other global privacy developments, including in many respects, I think Quebec's private sector privacy legislation has fallen behind. I was just mentioning that Quebec has fallen behind, and that it is now seeking to kind of modernize its legislation. Even before the implementation of the GDPR, there were some questions about whether Quebec's private sector legislation was adequate or met the adequacy standards of European law. And the reason why that's important is because it facilitates data sharing between Europe. It's a requirement in Europe that any data, transfers into other jurisdictions are transferred to adequate jurisdictions that provide similar levels of protections. And so another motivation behind this law might be to make sure that Quebec's legislation is seen as adequate with the GDPR to facilitate data sharing and data transfers between jurisdictions. The bill, so I'm just going to kind of walk through some of the key the key highlights of Bill 64. One section of Bill 64 is about accountability, and so one of the interesting things about Bill 64 is that it places the person exercising the highest authority in the business, so the president or the CEO, with responsibility for ensuring compliance with privacy laws. And so that's kind of a unique feature of Bill 64. You know, these accountability mechanisms can be delegated downward in the organization, but it does task essentially the president or the CEO with responsibility for privacy compliance. There's a requirement to develop privacy, governance policies and practices and making them publicly available. And making them publicly available might be a little bit more prescriptive than other privacy legislation elsewhere, but generally this is relatively consistent with federal privacy legislation. There's a requirement to conduct a privacy impact assessment for IT projects relating to personal information. This is, a lot of businesses would do this as a best practice. But the prescription or the requirement to do that under law is I think, relatively unique in Canada. And then lastly, on the subject of accountability, there's an obligation that IT offerings provide the highest level of confidentiality by default. And this is what is otherwise known as privacy by design. And it's the idea that consumers shouldn't have to kind of log into the software or pick a service to kind of upgrade their privacy, that the standard that is provided to consumers is the highest level of privacy protections, so that they don't have to do anything to get that higher degree of privacy protections. And this is somewhat controversial in the sense that it'll be a little bit more onerous if it's passed, if this legislation is passed, could be more onerous on businesses in the sense that, obtaining consumer data will be potentially more burdensome because it might require getting consumers to choose a setting, choosing a setting that allows more permissions and, allows more transfers of consumer data. In the topic of consent, the provincial legislation currently requires manifest, free, and enlightened consent. And that has always been an area of kind of confusion because it's not clear whether that meant that express consent was always required or whether, or whether other kind of implied consent or other forms of consent would be acceptable under Quebec privacy law. The Bill 64 changes manifest, free, and enlightened consent to clear, free, and informed consent, and then clarifies particularly that when you're collecting sensitive information, you need express consent. So the implication of that is that implied consent might be acceptable in other areas in kind of the collection of non-sensitive information. So, I think it probably doesn't go far enough in terms of clarifying, when express consent and implied consent can be relied upon, but I think generally people would see this as an improvement on the consent requirements. The Bill 64 requires you to identify technologies that use, geolocation and other kinds of profiling technologies, as well as opt-in options. And I think generally this isn't unusual in the privacy landscape. And I think David touched on automatic decision making, and Quebec has essentially a similar law on automated processing. They have, individuals have to be made aware of automated decision making. However, maybe it goes one step further, which is that the individuals have to actually have a right, if this law is passed as proposed, to have decisions reviewed by an employee of the business. So you'll be able to say, you know, this system made this decision about me, but I'd like this reviewed on this basis. You know, there's not a lot of clarification about precisely how that would work, but there is a mechanism for essentially objecting to how technology is processing decisions about a person. Bill 6 prevents or prohibits the collection of personal information from people, from children that are under 14 without parental consent, with some exceptions. This, although this is unique in Canada, it is not unique globally. This is these are, you know, the California legislation and other legislation have targeted the collection of information from minors. And then maybe just one last point on consent. There's no carve out for the collection of personal information relating to managing the kind of the employee-employer relationship. Although I know that that has been subject of a you know, of some work or some advocacy in just some pushes by business groups to kind of get more clarification there. Just kind of continuing along on major changes through Bill 64. Some people might be familiar with the business transaction exception in PIPEDA. This legislation allows due diligence exercises to involve the collection of personal information where certain protections are made. So just to facilitate due diligence exercises, allow the sharing of personal information without the consent of the persons whose information are being exchanged. The Quebec legislation essentially implements this exception, which would just help facilitate business transactions. In terms of outsourcing, you know, there is the focus of Bill 64, similar to, as David described, the federal legislation, is on the data controllers as opposed to service providers. But it does say that for when a data controller, when a company wants to disclose information outside of Quebec, they have to conduct a privacy risk assessment and ensure that whatever jurisdiction the disclosure is being made, it's providing an adequate protection for the personal information that's being disclosed. And would also require, kind of, I guess, in a similarly as the GDPR, would also require the province to publish a list of jurisdictions which would be deemed equivalent as Quebec. So that is similar to the GDPR, it's similar to PIPEDA, but is really quite, could potentially make disclosures outside of Quebec more complex and more involve a little bit more bureaucracy for businesses. Just in terms of other rights, I mean, data portability is one of the rights that is provided for by Bill 64. People will be able to kind of take their data and move it to another service provider or another company, similar to what David described federally. And one of the more kind of, I would say, interesting and kind of debate-provoking areas of change is Bill 64 would implement what is essentially a right to be forgotten. So this is the idea that users can make requests to be de-indexed from search results where the reputational harm from being indexed is greater than the public interest in free expression. And this is legislation that is similar to what happens in Europe. So in Europe now, European citizens can make requests to Google to have themselves removed from certain search results where, for example, you know, there's like lots of kind of classic examples, but you know, suppose if there was some sort of event that's kind of no longer accurate about yourself, and you know, let's say it could be, you know, some incident that happened many years ago, and that when you search your name, that incident always comes up, and it's no longer kind of reflective of who you are. That there is essentially an avenue for making a de-indexing request to Google, and Bill 64 would create that right in Quebec with some caveats and guidelines. Maybe just the last or couple slides on key changes. Breach notification. Although Alberta and the federal PIPEDA had a breach notification regime, Quebec did not. And so this legislation essentially adopts very similar rules federally. So organizations that collect information would have to report to affected individuals and to the provincial regulator, the CAI, where a data breach gives rise to a risk of serious injury. And so that's not, I don't think, will be very controversial, and it does kind of bring Quebec up to breach notification standards federally, but also globally. Enforcement, David mentioned kind of that federal privacy legislation is proposing to, have potentially significant administrative monetary penalties. The Quebec legislation also provides potentially very high AMPs for particular non-compliance, which could be higher for offenses. So somewhere between 2% of 4% of global turnover, which is quite large. But again, this is the maximum, and these would be for kind of particularly egregious circumstances. The Quebec legislation also institutes a private right of action. There's always a private right of action, but there's a kind of a great private right of action now with this bill, and also a minimum punitive damages for intentional breaches of the legislation. So just I guess maybe a status update. There's not the bill was tabled last summer. The bill is currently in second reading, and the next stage is clause by clause reading. We don't, I guess we're kind of staying tuned to what changes might be made to the legislation going forward, and it seems like there hasn't been much movement since the early fall. So there could be quite significant changes to the bill as I've described it. There's been a number of criticisms from business groups and other organizations. One of them is about this kind of notion that the CEO or the president is responsible, and there's concern about personal liability and how this delegation of authority might affect personal liability of CEOs. There's concerns about just the sheer possible amount of administrative monetary penalties, and without sufficient procedural protections and opportunities to cure breaches. On consent, I think one of the key targets or the issues is around this idea of confidentiality by default or privacy by design, which could make it just much more burdensome for businesses to comply. And then maybe the other broader issue, which touches on David's outline, is this notion that how do you making sure that businesses can easily comply with Quebec law, but also federal law or other provincial law. Some of these I would say Quebec is a little bit more, Quebec's Bill 64 is more prescriptive in terms of the precise steps that businesses need to take to comply, whereas the federal legislation is more permissive, especially around outsourcing and kind of data transfers. So, this is an area that I think business groups are pushing on to have a little bit more, a little bit more coordination with federal rules, given that many businesses, especially that are transferring data across borders, are going to be responsible for compliance with both the provincial legislation, but also the federal legislation. I'm going to jump. That was an overview, and I know that was a quick overview of a long bill, but we wanted to make sure that we also were able to spend some time talking about key decisions in 2020, just to bring folks up to speed with just some high-level points about major developments last year. So I'm going to turn it over to David.
It's not often that I'm muted, but I have to remember to unmute myself. A lot of people may think that's a good thing that I'm muted. But Michael, I was just going to say some of your remarks note that I didn't say anything about the status of the federal bill, so maybe I'll just quickly talk about that now. The bill was introduced in November. It still hasn't finished second reading. It's or been referred to a committee. It's had a fair amount of debate, but they didn't get that completed before the House rose for the Christmas break. So they'll be at it again at some point. The House comes back later this month, towards the very end of the month. And it's anybody's guess how it will progress. Of course, one of the other interesting sort of aspects of it is we're now in a minority government situation, which changes the dynamic. The bill is clearly part of sort of the current government's policy and a piece of its digital charter strategy document. But its ability to fully realize that in the current minority government is anybody's guess. So key decisions, as Michael said, we just, this is kind of a grab bag of ones that we thought were worth mentioning, and not always because of their particular facts, but more for what they might signify in a broader sense to other businesses. And one that I'm sure is familiar to many in the audience would be the well-publicized Desjardins breach and the resulting decisions that came out of that. And this was a joint. There was a joint investigation and joint findings by both the Federal Privacy Commissioner and the Commission d'Accès à l'Information. And I would say that the takeaway here and what was interesting about the case, ultimately, of course, Desjardins was found to not to have fully fulfilled its obligations under the Act with respect to its compliance framework, and in particular about its security safeguards. But I think the lesson for other organizations there are, I think sometimes there's a tendency when organizations address their information security to focus on external threats, hackers and whatnot. And so, a lot of organizations put a lot of effort in place, towards, implementing measures to prevent intrusion and, to control access to databases and all that sort of things. And my understanding is Desjardins did all that as well. The problem was really about what employees were able to do internally, and the apparent failure to detect some of that over an extended period. I think it was at least 26 months or something. So very briefly, what's happening there was that there were two different databases that Desjardins maintained. There was no issues about them being vulnerable in terms of external intrusions and uses. And internally, they had access controls in place that only certain employees could access these databases. But what was happening, contrary to the bank's policy, a number of employees who had access to these secure databases were routinely copying data out of those secure databases into a shared folder on a shared drive that also had access controls, but had different access controls. A much broader number of employees had access to the shared folder, and a rogue employee who did have access to that shared folder, but wouldn't otherwise have had access to the data in the more secure and restricted databases over a period of over 2 years at least, was able to copy that and actually exfiltrate that data. He apparently put it on a laptop that was taken home. It was downloaded onto USB storage devices and also removed, and none of that was detected. So the issue, I guess, there is, look internally as well as externally, and look in particular at prevailing practices within an organization that may not be documented, and in fact may be offside official policy. But as anybody who works in a large organization knows, is often employees find their own ways of doing things that may be more convenient, but may leave the company exposed.
And I'll just jump in on the Tim Hortons announcement. This is an investigation that the Federal Privacy Commissioner, as well as his counterparts in Quebec, BC, and Alberta, launched. And again, this is just all we know now is kind of a launch of an investigation relating to Tim Hortons's mobile app, which it was a mobile app that's designed for purchasing coffees and that kind of thing, and using it to go pick up coffees and track your rewards and that kind of thing with Tim Hortons. One of the allegations was that the app was collecting geolocation data for users even when they weren't actively using the app. And this is something that there was a couple of news articles about it over the year, and led to this investigation. Maybe just kind of I think one of our main takeaways from this is that geolocation is an area of increased focus by regulators. They think that it does potentially contain quite sensitive information, particularly when it's not just about using a service and using the immediate, not just for the immediate purpose of, for example, ordering a coffee, when it potentially collects data that's broader than that. And we're going to be looking for that in 2021 as a heightened area of regulation and focus by data protection authorities.
Yeah, I think that is the takeaway. Thanks for that, Michael. So the next one we've got listed here, which another fairly high-profile one, a Facebook investigation that again was at the was related to the Cambridge Analytica scandal, and there was an investigation about the ability of third parties to access certain data about Facebook users and use it for nefarious purposes. And for me, I mean, from the perspective of the Privacy Commissioner investigation, notwithstanding some of the particular facts and whether there was adequate consent or not, the interesting thing for me is, how it's sort of gone to litigation. So what happened was there's a report that of findings that the Privacy Commissioner issued. And there were a number of findings in that report that Facebook didn't agree with, and there were a number of recommendations in that report that Facebook didn't want to agree to. And some of the recommendations, one of them was a recommendation to do something that the Privacy Commissioner could not require, like it wasn't part of the statutory scheme. But it was something that the Privacy Commissioners, and this was 3 Privacy Commissioners, this was the BC, Alberta, and federal commissioners. So Facebook, in one case said, well, we're not going to do that because the law doesn't require us to do that. And so then the Privacy Commissioner, as is available to him, following an investigation and report of findings, can bring the matter to the federal court, and the federal court considers the matter de novo, and upon reaching its conclusion can issue whatever remedy or relief it thinks appropriate, including damages, injunctive relief, et cetera, et cetera. But I think it illustrates, for whatever side you're on, like on the on the Facebook or business side, or on the Privacy Commissioner side, it kind of illustrates gaps within PIPEDA potentially, that are now being addressed to some extent in the new bill. And so that, if the OPC would say it shouldn't be an option for companies like Facebook not to comply with, what the OPC thinks, needs to be done, what measures need to be put in place. And therefore, the fact that Facebook was able to do this here, it really underlines the need for direct enforcement powers and order making powers, audits, and all that sort of stuff. But, on the other side, I'd say companies like Facebook would say, they have no recourse currently. If the Privacy Commissioner issues findings and recommendations and they think that those are flawed or wrong, they don't have any right of appeal. There's no way of appealing that. It's not a decision. It doesn't have, legal consequences in that they can't compel anyone to do that. So it's even difficult to do it on judicial review. So really the only choice currently for businesses is not to comply or to suck it up and go forward with something that they think is an incorrect interpretation of the law. There is a mechanism now, which I didn't really talk about in a lot of detail, but in the CPPA, there's a new mechanism where the tribunal that I talked about would hear appeals in a kind of a summary way from Privacy Commissioner action. So again, the case just really illustrates one of the practical problems that C11 and the CPPA were out to address.
Yeah, and I mean, and just maybe picking up where David left off, because it's on the Facebook theme, and this also in 2020, the Competition Bureau entered into a consent agreement with Facebook in relation to not the exact same facts, but similar circumstances relating to the transfer of data to third-party apps, contrary or allegedly contrary to Facebook's privacy policy. And this is essentially the first action by the Competition Bureau in the privacy space, enforcing the deceptive marketing provisions of the Competition Act to direct it at privacy practices. And it was a large settlement, $9 million. And it is essentially a follow-on action by the Federal Trade Commission in the United States, but still quite important for businesses out there to just be aware that, there's potentially, especially where consumer data is very important to your business, there's potentially kind of a Competition Bureau angle to privacy compliance, not just a privacy law angle to that compliance.
And one of the other cases we want to highlight again, it's very topical. It's kind of sexy as sexy as privacy gets, I guess. The Cadillac Fairview decision, where this was a case about, those kiosks in malls that have directories and things on them, also had a kind of facial recognition technology. It was used to, estimate somebody's age and gender, and do it in a way that they weren't really trying to track individuals. It was about general traffic and collection of statistics. And I think that what's really interesting, I encourage people to read it. It's pretty detailed, but it really raises the question, I think, what is personal information and what isn't. And maybe, I guess there's a distinction, as I said at the beginning, personal information is information about an identifiable individual. And I think that my understanding is that this particular use could distinguish, a body from another body. So if Michael and I were both standing in front of the kiosk, it would know I was different than Michael and Michael was different than me. And it would record data about each of us that would estimate our age and gender, but it wouldn't know. My understanding is it wouldn't know that one was Michael and one was me. So I think that's it for us. Thank you for your attention this morning, and particularly for bearing with our various technical glitches, like all of us. I think we're doing the best we can in the circumstances, and Again, I thank you for your attention. There will be materials coming to you later. Thanks.